Well, a busy week to get underway here in Warren County as the second trial begins in the Crystal Rogers case. I'm Brennan Crain. Welcome into In the Know. Joining me today is attorney Ken Garrett. It's great to have you with us today, sir.
Thank you for having me.
Absolutely. Well, we're here to talk about this really big case. Folks have been watching this for a decade nearly here in Kentucky. I want to give you a moment, though, to tell everyone about your experience in law. Obviously, you're a defense attorney currently, but you've been on both sides of the courtroom with the prosecution and defense sides. Tell me about that.
So I was a prosecutor for a assistant Commonwealth attorney for about 4 years. I worked over in the 38th Judicial Circuit, which is north of Bowling Green. Also worked in the 43rd, which is in Glasgow and Metcalfe County. I did that for quite some time. After about 4 years, I got a little hungry to do something else and started doing defense work. I've been doing defense work ever since that point.
And as we mentioned, you have quite a bit of experience on both sides of the aisle. Tell me about your experience specifically in murder trials. These are some of the most heavily watched.
So I've been trying murder cases since probably, at least for my entire career, but probably for about the last 20 years. I've had as many as 10 murder cases on my plate at one time, stretched out in about 6 different counties. I get a lot of murder cases. I get a lot of impossible cases, and to me, those are the most intellectually challenging ones to try.
When you're sitting there, though, looking over the facts of the case, or someone comes in and says, "Hey, I need some defense here. I mean, they've got a lot on me." What is running through your mind as a defense attorney? And do you ever just say, "I can't. This is too. The prosecutors have too much. I won't win." Do you ever say that?
I've never said that. So there's a couple of goals to having a trial in a murder case. One is to see that the defendant gets the appropriate amount of justice, whether that is a not guilty verdict or to mitigate or minimize the amount of punishment they might get. Another goal might be just to, at least get all the facts out there to where a jury can decide whether or not they're guilty of the offense or not.
When you're working as a prosecutor, what's probably the most important thing you're focused on in a case?
The most important thing as a prosecutor, in my opinion, is to make sure that you can prove each of the elements of each of the offenses for which the person is charged. That's really the biggest thing that the prosecution wants to try to do. They want to make sure that each of those elements are covered with regard to different pieces of evidence coming in. They want to make sure that the jury is fully informed as to why the Commonwealth thinks that they can prove their case. And if you're able to show all the elements of the offense to the jury, then that's in the mind of the prosecutor, I think that's a successful prosecution. Despite what the jury may or may not decide.
Right. I have been a witness to some of the cases that you have been in the courtroom with, and I think an interesting fact of this, and something I want to get right into with this case, is that jury selection process. Also, we've kind of thrown it around out there. Most of the public doesn't know it as what you lawyers call it, which is voir dire, right?
Correct.
There's a lot of Latin in law, but tell me about your process. I've seen how you tend to focus in on the jurors eventually. Once you get that jury selected, you even memorize their names to a point.
So one of the things that I do, obviously anybody who's tried for a murder, which is as big of an offense that you can be tried for, one of the things I try to do immediately with the jury during voir dire is to build some rapport. And I also try to build some credibility. So on occasion I will memorize all the jurors' names, and that helps them to know that I'm grounded not only in the facts of who they are, where they might live, how many children they might have, who their neighbors are, et cetera, but also that during the trial, they know that I have a full and complete control of the facts. And so if during the trial, after having seen me conduct the voir dire examination, with either memorizing all their names or whatever else I might do, they know that they can trust what I say during the trial, because they've been given an opportunity to watch it in action when I called each of them by name.
So what we're expecting this week here is we're going to see Brooks Houck, the former boyfriend of Crystal Rogers, go on trial, and Joseph Lawson, who is a former accomplice / employee, however you want to look at that. Tell me about when you're trying 2 people in a case of this magnitude, how in the world are these 2 sets of defense teams going to work to make sure that their individual client gets a fair trial, even though the prosecution is likely going to be trying to connect their paths any chance they get?
So if two defendants are being tried together. Of course, there's two different defense teams. One of the first things they're going to do is make sure that their defenses align as much as possible. Or if they decide that they don't, then one defense team may try to shift the blame for one of the criminal offenses to the other, and vice versa. The other defendant may try to shift blame for an offense to the other defendant. So that's it requires a lot of thought, a lot of contemplation as to decide the strategy as to how you want to try the case when you have a second defendant being tried. And it does take some skill in being able to decide whether or not you want to try the case with a co-defendant, because honestly, the co-defendant may have more charges or something which is way more egregious than what the second defendant is charged with. And so that does enter into the calculation, quite a bit.
There are a lot of objections that I noticed being in the courtroom on this first trial, and I think with any trial, especially one where you're talking about people that come onto the witness stand with a lot of things that are particularly hearsay, or I heard this, or I think this. When you're talking about two defendants in the courtroom, in your mind as a defense attorney, do you approach the other person's defense, and do you work with that defense, or do you stay in your own lane? How do you really get into that process?
So one of the first things that I have to decide is this second defendant or third defendant who's going to be tried with my client, are they going to be aligned with my interest? Or are they going to be so disjointed or distant from what I want to prove that I may not want to cooperate with that defendant? Now, most successful defenses where you have multiple defendants, most of those are successful only because each defendant is, their defense is consistent with the other defense. Because obviously, if each defendant is saying the same thing, then they're doubling up on what they believe is the truth. And they're repeating the same thing to the jury. And so the jury has been given not only one opportunity to hear it, but a second. And so what that does is it dilutes what the prosecutor says.
That is interesting. The big part of this case, and I think a lot of questions are coming out of this, is we have certainly one defendant charged with murder, but the other two are charged with conspiracy to commit murder. Nonetheless, murder is the word, but there is no body. How do you try a murder case when you don't have a body? You don't even know technically if Crystal Rogers is out there somewhere living her life. That's what defense attorneys for Stephen Lawson even suggested during one point in the previous trial. How do you try a case like this?
So the question is whether or not there is a body or there's not a body is really fact determinative. If there were lots of evidence to come in to suggest that she had a routine and on Sunday she did this, she went to dinner with her family, and then for the remaining days or remaining Sundays after, that never happened, or if maybe one of the defendants said, I'm going to harm her, I'm going to hurt her, then you add those things up, and of course there would be much more examples of why she isn't here to show that obviously either somebody has unalived her or something has happened to her. But in the case where you don't have a body, you have to basically prove circumstantially that she's not doing the same thing she was, or defendant 1 or defendant 2 says they're going to harm her. Maybe there was an altercation, and so you take all those things together and use that to basically infer that someone may have unalived her.
So obviously, again, we've talked about there are 3 co-defendants here. One has been found guilty. Is that a concern for the defense of either of these men going into the second trial, do you think?
So it could be. And one of the things as to why the prosecution may have done that is once they got a guilty verdict from the jury, one thing that they may have done was entice the defendant to talk to them in exchange for a lesser sentence. So if the prosecutor wanted to say, look, I know they gave you 17 years, but we're going to try to get this lower for you, then they may engage in some sort of negotiations to make that happen. But usually that's what happens.
So you're saying that in this period now between Stephen Lawson's trial and August 6th sentencing date, there could be some of those conversations happening?
Yes.
Do you think that we might even see him on the witness stand in this second trial?
Possibly, but because he's held out so long and demanded a jury trial, I would bet that he probably will not do that.
It was really surprising, I think, to see that he actually took the stand, and that's just my opinion. You know, being there in the courtroom, I think it was surprising because usually, and as we know, a tenet of our justice system is no one has to prove their innocence. But for him to get on the stand was interesting. What do you think going into this second trial here, where there are so many other factors at play? The public knows a lot about this case given its pretrial publicity. There have been some documentaries, podcasts, things like that. That's been a big concern for Judge Sims, I think, as far as making sure that you know, the eventual jury is not tainted by those things, but it almost seems impossible. What's the way that these defense attorneys especially are going to try to get around that?
So, you know, the first thing that was done, of course, was a change of venue. They did bring the trial from Nelson County down to Warren County, so that does help. Oftentimes, though, like on a case like this, I mean, there is a substantial amount of pretrial publicity, and the goal in moving a case to a different jurisdiction is to maybe minimize the amount of people that have heard about the case. And so one of the goals, or I guess one of the objectives of the defense attorneys is to try to get, of the pool of people who have been summoned to court, get those individuals out of that pool who have not heard about the case. But still, it's very difficult to do that. Obviously, a trial of this magnitude does create a lot of pretrial publicity. It's kind of a sensationalized case, and of course, it's been going on for some time. So by this point, there's a lot of saturation as far as opinions, even in Warren County. But the goal is, of course, to weed out those people who have already formed opinions and try to find those who have been, for lack of a better term, living under a rock. Sure.
It's one thing to obviously ask people if they've heard about the case, if they formed an opinion. From a defense perspective, though, what are you really trying to look for? Because even as a member of the media, we were not in the room during that jury selection process. Obviously, there were 80-some people summoned, so it was very crowded. But what are you looking for from people? Are you watching how they react to questions? Are you looking for anything that's subliminal in your perspective?
So in my experience, usually what I will do is, number one, I will look to see, number one, what they're wearing. Are these name brand clothing? Sometimes I'll look at their shoes, determine what their habits are. Are they well kept? Sometimes you may find someone who comes into the courtroom and they're not very worried about their look. And so for me, the person who is a little bit disheveled or whatever may be a more independent thinking person. So what you want to look for, or at least in my opinion, is I want to look for people who are conformist, who will follow others. And then I'll also look for the independent-minded people who could basically commandeer the jury and lead them the other direction.
You mentioned that this case has been going on for some time, nearly a decade, but the indictments came in 2023, which means that, you know, the defense has had a couple of years with most of the people, except Steve Lawson. We have talked about how his team he fired his attorney about 9 months before trial, and that lent to some frustration with his new team, even trying to get the case continued a little bit. But with Brooks Houck and Joseph Lawson, their teams have been together a little bit longer. Describe what do you think? They've said that there are several terabytes. I mean, that's a large amount of data. There's that much discovery in this case. What are you typically given as an attorney with discovery? I mean, is it surprising to you to hear that a case like this is 2 terabytes big?
No, that doesn't surprise me at all. So there's a ton of different types of evidence that you can be given. Obviously, the FBI and several other agencies were involved in this case. So anytime, let's say, law enforcement touches the case, they're going to reduce to writing some sort of report. There's experts who the law enforcement may rely on, that whether it's the Kentucky State Police Crime Labs or the FBI, one of their crime labs. All those people are going to, write documents out, test results, et cetera. And the like. And then, of course, you've got witnesses, you've got videos, you've got audio statements. There's a ton of stuff that would go into the discovery. And essentially what the defense attorney has to do, or at least in my opinion, a successful, smart defense attorney would do this, is to go through every single bit of that discovery. If that, sometimes at least nowadays, you have cell phones, and oftentimes a cell phone can have 200 or so gigabytes of information. And so what you would want to do is run through all the text messages. You would want to see what pictures were taken, where those pictures were taken. Sometimes there's geolocation on Apple iPhones that will tell you where a picture was taken to determine whether or not your person was close to that area. You would also look to see whether or not any Snapchat or any other third-party social media apps were running at the time, whether they picked up any information. But when you go to start looking at cell phones and things of that nature, it's really easy to add up a ton of gigabytes, and of course, a terabyte is 1,000 gigs, and so it's not unusual for a case to have several hundred gig, but a couple of terabytes for this, I think that's probably about right.
And included in that discovery, as we learned in the pretrial motion hour, were the cases of Jason Ellis and Tommy Ballard. Of course, that's the Bardstown police officer and Crystal Rogers' father. Those folks have been rumored in the documentaries, the podcast, all that sort of thing. I think the public has drawn the conclusion that they are involved in this some way, somehow. Certainly the public has formed its opinion about that. But how do defense attorneys keep this separate, even if the prosecutors try to slide in some information about those other cases? So
the key question is whether or not the information from those other two cases are relevant to the charges which the defendant might be facing in this case. Sometimes a prosecutor may want to slide in other pieces of evidence from another defendant because it's very salacious or it's very inflammatory. It's something that would easily cause the jurors to get upset about, and so they can transfer that anger or feelings about that defendant to one of these. And so the way that that's kept out is there's some evidence rules which keeps out everything which is not relevant to the case at hand.
And it's pretty much the burden of the prosecutor to make sure they don't introduce those elements?
That's correct.
Okay, all right. So we're talking about, again, all of these records, and even records that are relevant. The judge has mostly ordered all of them sealed. Why do you think that's the case, and what's the justification for that?
And the records you're talking about would be records from the investigation, or?
Well, yes, technically we don't know, I guess, most of the investigative records, because those are, a lot of that's in discovery, but I'm talking even just basic motions. Like this morning, there was a motion entered, but it was sealed. We have no idea what it was. What's the justification for that?
So, I would have to speculate, but my guess is so that it doesn't taint the jury. Sometimes maybe a defense attorney might ask for something, and just the mere asking for that particular item or that result or whatever it is could skew the jury if, let's say, the media got a hold of it and then there's a lot of conspiracy going around. So the goal really is to protect the jury itself so that no one hears that information, because when you seal something, obviously you just don't want the jury to have that information because it may not be relevant, or it may be too inflammatory or incendiary to the other defendants which are currently being tried.
The next step, it seems in my mind, and I'm obviously not an attorney, but for prosecutor Shane Young to have secured a guilty verdict in 1/3 of the case so far, the next question is, well, can we compel somebody to tell us where Crystal Rogers' body is? Is there any legal way a prosecutor could work that information out of someone?
So the only way that, in my opinion, the only way that would happen is if the prosecutor believed that, let's say, an individual who held that information as to where the body was, if the prosecutor believed that that individual was somehow involved in it, then obviously they could say to that individual, we believe that you were involved in this, we're going to charge you for X, Y, or Z. And a criminal charge, at least at the felony level, is quite the motivator to share information so that you yourself don't end up going to the penitentiary.
Mm-hmm. And do you think, though, that in this case, is there a path for that? Like, hypothetically, is there a way, if Stephen Lawson knows that information, is there a way to get that out of him, even though he's already been convicted?
Yes, there would be a way. If he's aware of it, I think there would be. Obviously, his defense team could go to the prosecution and say, all right, we have a piece of information we would like to share with you. In exchange for that, we would like a reduced sentence. Or we would like to negotiate this to a reduced sentence.
And is it typical to withhold the information until the agreement to reduce said sentence is done? Interesting. So I think one of the big things I want to talk about too is just procedural. We saw a lot of moments where the attorneys approached the bench where the judge was. The static was playing across the courtroom. There was some audible frustration from Crystal Rogers' family sitting just behind me during those moments. And I'm assuming the other side of the courtroom, I didn't hear those folks. But what's happening during a bench conference and why are they so secretive?
So secretive, I wouldn't necessarily characterize it as being secretive. I would characterize it more of making sure that the defendants had a fair trial. Sometimes an objection may be made by the defense to keep some particular piece of information out of the trial, some piece of information which may be inflammatory or not necessarily relevant to the charges at hand. Some other times maybe the prosecutor will object to something, and it's basically to make sure that each side is getting as level of a playing field as possible, because you wouldn't want to introduce some aspect of somebody else's case or some allegation into the trial if it didn't directly affect those two people or one person who's being tried by the jury.
Now, the next question I have might seem a little off-putting, but there is a lot of showmanship in the courtroom from both sides, prosecutors and defense attorneys. My question, though, is do you believe that that showmanship is convincing enough to the jury most of the time to influence them, or are attorneys just having fun?
I mean, being a defense attorney, I wouldn't necessarily call it showmanship as much as I would just call it advocating for the client. Obviously, when the defense attorney steps in there, anything and everything they do, from size in the courtroom to the way they handle walking away from the bench, all of those things are designed to basically let the jury know how they feel about something. And oftentimes, actually I would say 100% of the time, jurors pay attention to every little thing that happens inside the courtroom. I had a trial one time where, this has been years ago, but I was trying a case in Glasgow, and the prosecutor turned to me and said something really, really scathing. And what I heard a juror to tell me later was that she was telling one of her friends, she said that Mr. Garrett sat there, he didn't flinch, he didn't budge one bit. And the reason why I didn't is because I wanted the jury to know that despite what he said, it still didn't bother me and it had no effect on my case. That is, the words he said were hollow. They weren't going to do anything to my belief about my case. And what I hoped to show the jury was that despite his saying that, it had no effect on the case, and that was a not guilty verdict. Not just because of that, but I think it's helpful that when you are advocating for your client, that every single thing you do is always being watched by one of 12.
Sure. We'll right into that next question. You know, we saw Stephen Lawson take the stand in his trial, and there was a pattern of lying presented by the prosecutors. They suggested he couldn't be trusted, and that I think that was their form of discrediting anything that he might have said or suggested about the investigation. But he decided to get on the stand. If this happens in the second set of trials, whether it's Brooks Houck or Joseph Lawson, do you get to still maintain your Fifth Amendment right when you get on that stand, or do you have to answer everything you're asked?
So once you take the stand, you have waived your Fifth Amendment right. So if in the middle of the testimony he decides, he didn't want to say anything anymore, obviously he can assert his Fifth if he really wanted to. It's not going to work. But even the mere mentioning of asserting the Fifth in front of the jury is at this point going to look like he's got a lot more to say, but he's wanting to hide it. So I think, number one, it's you can't really assert your Fifth after you've started testifying because it's waived. But secondly, even if you did attempt to do so, the jury is going to punish you severely for even attempting to assert your Fifth, because they think you're going to be hiding something, and and I would say also they don't think you've been fully forthright.
And that's the reality, right? But technically, the jury still shouldn't even consider that, even though they still do.
They shouldn't, but I can promise you they do.
Yeah. Okay. So I'm kind of skipping back to one thing I've already asked you, but I do want to reiterate that in this case, a murder case where we don't have a body, and you've already talked about that, but we talk about this thing called circumstantial evidence. Tell us, what is circumstantial evidence? Maybe give an example and describe from a prosecution standpoint, Is it more challenging to present a case when you're only going on circumstance rather than hard physical evidence?
So circumstantial basically is a piece of evidence that requires an inference or requires you to draw a conclusion based on something that may not be there. For instance, let's say the arsonist there was a shoe print at the scene of an arson. The arsonist allegedly had a size 14 shoe. So you would then be looking for people who had a size 14 shoe. Now, just because defendant A wears a 14 doesn't necessarily mean it's him, but it's certainly some pretty good circumstantial evidence that it could be him because he would fit the characteristic of the arsonist. And there's different types of evidence. So there's direct evidence. For instance, you've got a video of someone committing an offense. You've got circumstantial evidence, which we discussed. You've got physical evidence. So if they had the murder weapon, then obviously that is a piece of evidence. You've got testimonial evidence. Testimonial evidence is anything that witnesses say from the witness stand. And then obviously those are subject to, crossed by the defense attorney to see whether or not they're biased, whether or not they were able to recall, whether or not they were in a good position to actually see things. You also have demonstrative evidence, and demonstrative evidence, I've used that a couple of times in trial, and probably the best example I can give of that is it's basically trying to demonstrate maybe a scientific principle to the jury, but you can't do so. So like for gravity, you can't really, it's hard to kind of tell them what gravity is, or like for aviation, this is one that I used in a trial, what pitch, yaw, and roll was. So what I did is I had a toy plane in front of the jury, and I showed them what pitch, roll, and yaw was. And so they were able to understand that, and the way that came in at trial is a safe was lowered into a well with a piece of evidence in it, and when the safe was lowered into this well, it did pitch, roll, and there was some yaw to it, and so that was important because it would have required two people to manipulate that safe down into this well. So those are the different types of evidence. Obviously, the best piece of evidence would be direct evidence, something that there's not really subject to challenge, but we're not so lucky to have that always in a trial.
Sure. Talking about evidence, before, whether it was prosecutors or defense attorneys entered something or wanted to enter something, there was always the question from the judge if the other side objected. And I don't think, I'm kind of putting myself on the spot, I don't think there were any objections to any evidence from either side. But why is that question posed? And does there have to be a strong argument to oppose evidence being put on the record for the jury to help decide their case?
You don't necessarily have to have a strong argument, but oftentimes on the defense side, what we would want to do as defense attorneys is we want to protect the record. And what I mean by that is, when you try a case, trying the case in front of the jury is one aspect of zealous advocacy for your client. But another aspect of that is, in the event that this case goes to the Court of Appeals or the Supreme Court, part of what your defense action should be is to protect the record. So in the example of objections being raised to evidence, part of what you are doing is when you go to the bench and speak into the microphone in front of the judge is you're sometimes speaking to the appellate court to say this is why this piece of evidence shouldn't be put into this trial. So in addition to telling the appellate court that, you're telling the judge that, but you really have two different audiences. And so your immediate concern is trying to keep the evidence out of trial at that moment. But in the event that you were not successful and you lose the case, then you can take the information that you've spoken into the record, that is the microphone and the video recording system in the courtroom, you can take that information and appeal it to the Court of Appeals or the Supreme Court, and they may decide that, okay, well, the objection that you made for your client was correct, the trial judge was wrong, and so they may end up, deciding differently if you have to take the case up on appeal.
And that would make sense. So I do stand corrected then. While there may not have been that typical objection, screamed out in the courtroom, there were several moments where, perhaps the prosecution wanted to enter something, and then that question, may we approach, right, routinely was coming up. We talked about, if you're putting your own client on the stand, but in a two-person trial like this, what if the co-defendant gets on the stand and says something that could be incriminating to the co-defendant? What happens then from that defense side? So
normally before two defendants are going to be tried together, both the defense attorneys and even the prosecutor to some aspect are going to determine whether or not these defendants are going to be adverse. If the defendants will be adverse to each other because of the right to confront for one defendant and then the right to plead the fifth for the other, sometimes you'll have a case where those two defendants may not be tried together. So, for example, if I wanted to make a statement about you, or I had made a statement about you, and it directly implicated you in a crime, but you then took the fifth and I didn't have the opportunity to cross-examine you about that or to inquire about it, then that means you would basically have to be tried separate. Because when the right to confrontation and then when the right to not to incriminate yourself, when those come into play and they're adverse to each other, then you've got a problem where you just can't try those two individuals together.
And it appears that there was some of that going on in this case, because I think the prosecutor and defense team for Stephen Lawson recognized that he did have a pattern of inconsistency and pretty much was looking out for himself throughout the entire investigation, not necessarily covering so much for someone else as much as he was trying to make sure he was covered in his tracks. We're on the downstretch here. I do have a couple more questions for you. We've got a lot of good questions from the audience and folks, that have been watching the trial coverage through this. One big thing I think I want to ask you, because attorneys said that they couldn't describe in the courtroom, but we're not in a courtroom here, is this whole phenomenon of proving the case beyond a reasonable doubt. What does that mean, and why in the world can't a defense attorney or a prosecutor tell the jury what that means?
So by law, and the way the system is set up, you really can't try to define reasonable doubt. It is just basically what its common sense understanding is. But just the way that trials are set up, the burden is basically beyond a reasonable doubt, but each side is not permitted to define what that is.
Have you ever been in a moment where maybe the prosecutor, or even when you were a prosecutor, when the defense was trying to sort of get what that meant in there to the jurors?
It's probably rule number one is don't define reasonable doubt. So most learned attorneys will not attempt to do that.
And I think it's fascinating. Sometimes I wonder why in the world didn't I pursue law? I just think the theory is so fascinating of, at the end of the day, when the jurors get back there into the deliberating phase of the trial, it's each individual's requirement to faithfully execute that duty, which means that, let's say we have 11 out of 12 in a criminal trial. If we have 11 out of 12 and there's only one person with some doubt, that means there can't be a guilty conviction, right?
If they stand their ground.
Right.
If you've got 11 for or 11 against and then one opposed, then basically at that point it would be a hung jury. And one of the things that the system has done, or at least one of the cases long ago, 1896, there was a case, Allen versus United States. It was a case basically to give a jury an instruction to continue to consider what the evidence is and to see if they could reach a verdict, and that was to prevent a hung jury, because if they're stalled at 11-1, then that's a hung jury. Now, in Kentucky, that's covered by Kentucky Rule of Criminal Procedure 9.57, to where there is what's called an Allen charge given to the jury that if they're deadlocked, the court or the judge will basically instruct them to continue deliberating until they have fully exhausted all possibility of a resolution. And sometimes the Allen charge can result in one of the sides caving and going the other direction. Now, that's not to make them do that forcefully or anything, or to do that against their will, but it just, the court basically asked the jury to reconsider and simply go back and look through the evidence again, and sometimes it is successful to where a verdict is rendered.
Now, on Stephen Lawson's appeal, he has indicated, his team's indicated that they're appealing his guilty conviction. They're citing the fact that the jury only deliberated for 3 hours, which they, or nearly 3 hours, which they are saying is way too few hours to be deciding a man's fate when it comes to conspiracy to commit murder. Do you think that's the case, or do you think it's going to be hard to argue that? Isn't it just what they think? How can you tell the jury they made it too quick or too slow?
I'll just say this. In my opinion, I think that the jury can take as much time or as little time as they want to render a verdict. I mean, I've had a verdict of a not guilty back in less than 10 minutes. But timing itself as to how long the jury takes to deliberate does not equate to some violation of a defendant's constitutional rights. It may be that the evidence was that clear, or that one party didn't execute their job as best they could.
The witness list. Folks have asked me questions about whether the prosecutors have to give the witness list to the defense or vice versa. At the end of the day, do we know who could be called in a case like this?
So the prosecutors are required to give a witness list to the defense. The defense, however, they are not required to provide a witness list to the jury before they put their case in chief on. And they also don't have to give a witness list to the prosecution at any time.
Why is it built like that, do you think?
So, the burden of proof is always on the government, whether that is the Commonwealth of Kentucky or the United States. And in order for a defendant to fully embrace his right to a fair trial, he doesn't necessarily have to reveal things he's going to say, witnesses he's going to call, experts. The experts do have to be revealed beforehand, but oftentimes it is that a defendant doesn't necessarily have to share their case with anyone until they're ready to put on their case in chief before the jury.
Interesting.
And that's just a protection for the right to a fair trial.
Right. The sentencing phase of this, we're all watching that. The jury recommended, it's important to say recommended, 17 years for Stephen Lawson, and certainly the stakes are higher for Brooks Houck being charged with murder. But when we get to sentencing in August for Stephen Lawson, even though the jury said 17 years, could Judge Sims technically give him more time?
Yeah, so usually the jury will give a recommendation. And then at sentencing, the judge will determine whether or not to accept that recommendation on the part of the jury. Although the judge does have the discretion, if he wanted to move that upwards or downwards, he certainly could.
What about with the actual verdict? The judge can't change a verdict, though.
Judge cannot change the verdict.
Okay. And the last question really I have today is people are asking, why did this take 10 years? And obviously the FBI got involved in 2020, so even 5 years after Crystal Rogers went missing. Why would it take, though, 10 years for this case to even make it to trial?
So when we first started the interview, one of the things I said was that the prosecution wants to make sure that they have all the evidence they need to prove each of the elements to each offense against each defendant. And essentially, sometimes it can take a long time to get a sufficient amount of evidence the prosecutor believes will be necessary to prove to the jury to get a guilty verdict. And so, in my opinion, probably what happened is the prosecution, and I know Mr. Young is very conscientious about proving his case. He's very conscientious about what he needs to get into trial. My bet is that he decided to make sure that he had all his ducks in a row before he was willing to try the case in front of the jury, because you basically get one chance.
Well, as you can see, a lot of information to unpack here, and we are going to be following this case until it ends. We have no idea at this point if this case will end by the end of this week, end of next week. It could go on for a while here, again, with 2 co-defendants. We'll be following it every day. I'll be in the courtroom, one of 20 members of the media reporting here nightly for you on WBKO and on the web. And you can follow my Facebook page as well for daily updates and those behind-the-scenes updates during court recesses. For now, I'm Brennan Crain here with Ken Garrett, attorney at law. Have a great day.